Welcome to Law Symptoms. My name is Ravit Singh and I'm a third year student of the Gujarat National Law University, Gandhinagar, currently interning at Law Symptoms. The topic that we'll be discussing today is the Maharashtra political crisis and the issues concerning it. So, first of all, let us take a look at what the crisis is all about. The Bharatiya Janata Party and the Shiv Sena ran as an alliance in the 2019 Maharashtra Legislative Assembly elections. Their alliance was called the Mahayuti Alliance. Under the banner of the Maha-Aghadi coalition, the Indian National Congress and the Nationalist Congress Party ran. The Shiv Sena won 56 seats, the NCP won 54, the INC 44, and the BJP won 105 seats. Soon after, disagreements between the Shiv Sena and the BJP arose over the power sharing arrangement that was to be followed. In the end, the BJP severed ties with the Shiv Sena, one of their longest allies. The Shiv Sena then decided against backing the BJP in creating the government. Shiv Sena eventually joined the INC and NCP-led Maha-Aghadi alliance to create the Maha-Vikas Aghadi alliance, gaining the necessary 145 seats to achieve the majority status. The MVA alliance resolved to install Uddhav Thackeray as the chief minister and form the government. After instances of cross-voting were reported in the Maharashtra Legislative Council elections on the 20th of June, Eknath Shinde and a few other Shiv Sena MLAs rebelled against the administration, dealing a severe blow to the MVA government. The Shinde group rejected Thackeray's continuous offers to step down as chief minister and party leader in an effort to appease to the rebels. On 30th of June, Uddhav Thackeray resigned from the post of the chief minister of Maharashtra and said that he will also resign from the Maharashtra Legislative Council after the Supreme Court decision, though through an address on social media. Coming to the the legal issues that are involved in the crisis, a few can be made out almost immediately. The first one is regarding the floor test. On 29th of June, the governor of Maharashtra ordered a floor test to be conducted in the House. The Shiv Sena immediately moved to the Supreme Court against this order. On the same day, the Supreme Court refused to stay the no confidence motion and ordered it to be conducted on the 30th of June, that is the very next day, stating that the floor of the House is the only way to settle all the issues. In the SR Bommai case, it was held that the floor test upholds the collective accountability of the elected government to the legislature. The principle of democracy enshrined in the constitution demands that the issue, whether the government commands the confidence of the House, be left to a vote in the Legislative Assembly. The Supreme Court had ruled in Shivraj Singh Chauhan versus Speaker, Legislative Assembly of Madhya Pradesh and others, that the government has the authority to order an incumbent chief minister to undertake a test in order to show the legislators' confidence in their government. In Shiv Sena versus Union of India in 2019, the court had ordered the governor to convene a floor test and set a time frame for it. The reason behind such an insistence on conducting floor tests is that, as elucidated in the Shiv Sena case, is the possibility of horse trading. Therefore, the Supreme Court is of the view that an immediate floor test is the most effective mechanism to protect democratic values. In accordance with a unanimous report from a committee of governors appointed by the President of India, which was cited in Justice B.P. Jeevan Reddy's decision in SR Bommai case, the governor would be required to take action to form a substitute ministry if the chief minister were to disobey his order to take a vote of confidence. The chief minister's reluctance to take the exam can be taken as a prima facie sign that the legislator does not have confidence in them. Although the governor's powers to judicial review, the governor's powers are subjected to judicial review. In Nabam Rebia versus Deputy Speaker, Arunachal Pradesh Legislative Assembly, Justice K.S. Keher had Justice J.S. Keher had noted that the governor may exercise his power under Article 174 on his own without any assistance or advice if he has reason to believe that the Chief Minister and his Council of Ministers have lost the confidence of the House. To determine if the House has indeed lost confidence in the Chief Minister, a trust vote must be held. The persistence of that trust is essential to the legitimacy and by extension the survival of the government. It is an issue that cannot be delayed since the Council of Ministers' ability to maintain the trust of the legislative body as a whole is essential to the authority of the government led by the Chief Minister. The second primary issue that can be identified is with regards to the anti-defection law. Now, the Rajiv Gandhi administration had introduced the anti-defection statute through the 52nd constitutional amendment in 1985 in order to stop simple political defection. According to the law, a legislator, if he voluntarily gives up his membership of the party or refrains from voting, or for that matter votes against the directions of his party, he can be disqualified from being a member of the House for the remainder of his term. The procedure for how the presiding officer of a legislature may disqualify a legislator on the basis of defection based on a petition from any other member of the House is outlined in law for both state assemblies as well as the parliament. In 1992, in the Kyoto Holohan case, the Supreme Court had ruled that the 10th schedule hearings before the Speaker are comparable to tribunal proceedings and can therefore be subject to judicial review. The decision made by the Speaker can be challenged on 4 different grounds. The first one being that the ruling has been made without accordance to the principles of natural justice. The second is if the judgment is unlawful. The third is if the order made is in poor faith or is malified. And last but not least, the order may be deemed perverse if it is based on no evidence or utterly untrustworthy evidence. According to the Kyoto ruling, judicial review cannot be granted at a stage prior to a decision being made by the Speaker. The third para to the 10th schedule was omitted by the 91st Constitutional Amendment in 2003, effectively nullifying the exemption that if 1/3 of the total party membership were to defect, then such a defection would be deemed sound in law. Now, the only exemption that remains is para 4. That states that a valid exemption to the anti-defection law would be a merger with another political party supported by 2/3 of its MLAs. To conclude, it may be stated that even though the rebel MLAs have not tendered their resignations, the Supreme Court in the Ravi S. Nayak case held that a variety of conducts may be construed as effectively having given up party membership. So, as the post of the Speaker in the Maharashtra Legislative Assembly remains vacant, therefore under Article 180 Clause 1 of the Constitution, the powers of the Speaker